agnostics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government, hug the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Michael Baranowski, a professor of political science at Northern Kentucky University. I'm joined today by my conservative counterpart, Cleveland area attorney and defender of freedom, Jay Carson.
Hey, good morning, Mike.
Hey, Jay, how you doing this morning?
Well, I will try not to lapse into tears here on this podcast.
That's okay. Well, that's certainly at least.
Well, I mean, sometimes I like to make these a little subtle if people haven't been watching. But
There you go. Okay. Anyway, well, we will hope Jay doesn't lapse into tears. Who knows what we will lapse into? But we do have a lot to talk about today. We're going to talk a little bit about Kevin McCarthy and what he did or didn't say, the lie in New York Times, or maybe not actually. And the big ruling against the mask mandate, Ron DeSantis versus Disney, latest in Russia and Ukraine. It's this last week was tax day, so we'll talk about tax policy. It was also 420 day, big day for a lot of people, I guess, including Elon Musk. And then we'll talk about marijuana policy. And then our uniquely stupid last decade, at least according to Jonathan Haidt. We'll get into that. And maybe more, who knows, but that's a lot on our plate, and we will get right to it in just a second. Okay, Jay. So on Thursday morning, the New York Times reported that House Minority Leader Kevin McCarthy had told colleagues, specifically Liz Cheney, that after January 6th, he was going to suggest to Donald Trump that he resign. And when that reporting came out on Thursday afternoon, McCarthy issued a blanket denial and called the New York Times' reporting totally false and wrong. And then, on Thursday evening, two Times reporters provided audio with McCarthy saying, exactly what he said. The New York Times was totally false and wrong in reporting. And so one would think that, that might cause a problem with Donald Trump, but all reports indicate that Donald Trump seems to be perfectly okay with Kevin McCarthy at this point. And I should point out that's hardly unprecedented. Just last week, Trump endorsed Ohio Republican Senate candidate J.D. Vance, who in 2016 called Trump cultural heroin and unfit for our nation's highest office. So, Jay, in listening to all this and following all this, you're our House Republican, so to speak. And what does all this tell you about, McCarthy, Trump, and Trump's hold on the Republican Party at this point?
Well, I think a couple things. One, look, there are intrapartisan rivalries and headaches are much more common than I think most people think. I can tell you in my career, to the extent I've had a career, if you want to call it that, it's people of my own party who have given me many more headaches, much more angst than anything the Democrats ever did. And there's sort of a lot of reasons for that. It's sort of, part of it is, family fights are always the worst and that kind of thing. But it's also, it's just the nature of any kind of political organization, right? Everybody's striving and climbing. And there are factions and there are factions within factions. And at the end of the day, though, you still have to put a cohesive team on the field, or try to put one on the field. So to me, it's not at all uncommon that this type of thing would happen of McCarthy musing that, look, Trump should resign, saying that to Liz Cheney. It's also politicians being what they are. It's not surprising that he maybe forgot that conversation or remembers it differently. Or is just plain lying about it. Now that it's not helpful to be caught with it. So all that said, I think this is kind of politics is usual, and I think there's probably plenty of times Trump would have said something about, I wish I could get rid of that damn Kevin McCarthy. And I think the virtue with Trump is he tends to say everything publicly. With all that, I think something that's a little different is now the Trump walking back the right. I mean, before it would have been, all right, Kevin McCarthy's dead to me, J.D. Vance is dead to me, um, but he's moderating a little bit, and I think that's a function of looking at one who he thinks is whatever the strongest horse in the Ohio Senate race, and two, realizing that Kevin McCarthy is someone that he has to work with, and not vice versa.
Does he really, though? I mean, it seems to me that Jim Jordan could make a very strong case for being Speaker of the House in January of next year, and it wouldn't surprise me at all. I mean, he's been a Trump guy from the beginning and never, said things like McCarthy has said. And so I wonder if this is just a way of just sort of keeping McCarthy so he's not so much of an issue, a problem, just keeping him from kicking too much until the next Congress convenes, and then you can have Speaker Jordan, who's been a Trump guy, all the way along.
Yeah. Well, no, I mean, I think that's not inconsistent with what I just said. That it's not. There's no upside for Trump of starting a brawl with McCarthy right now.
Right. And so, but
so look, if I suppose he could be out there making the pitch of I want Jim Jordan to overthrow McCarthy next year, but part of this is I think there is something in that. The Trump influence has waned. I'm not going to say it's gone away. It certainly hasn't.
How do you get that when you look like in the Ohio Senate race where people were just falling all over each other to try to get Trump's endorsement? And it's also weird, you say Trump's trying to pick the winning horse. That's just factually, I mean, at least from the polling, not true in the Ohio Senate race, because if he was going to do that, he would have gone with Joshie Mandel there, and he decided not to do that and go with the candidate who's considerably further behind in the polls. And so I think your narrative is largely wishful thinking. It's that you truly want to believe that Donald Trump's influence is waning, but I think that Donald Trump and Trumpism is just as strong, in fact, if not stronger, than it really ever was. And I understand you not wanting to believe that's the case, but it just seems that the facts just contradict your wishful thinking here.
I'm not sure. I'm not sure how you're getting that, because to me, I look at this, and if Trump is the fact that Trump didn't endorse Vance over Mandel. Now, there are a couple things that could be playing in on that. Some of them could just be weird Trumpy sort of, hey, Vance is a celebrity of sorts, right?
Sure. Yeah.
I mean, not Hollywood celebrity, but he wrote a book and they made a movie of it. He's not hey, this guy's the former Ohio treasurer.
Yeah.
You know what I mean?
Sure. Yeah. Absolutely. He loves celebrities. Yeah.
The outsider piece of that. Second is, it's almost as if Trump needs, and this is what I'm trying to get at. Trump is broadening his appeal a little bit, or trying to, right?
How so? I'm not following.
Well, so for example, I mean, if Trump had, let's put it this way, if Trump had the horses, so to speak, to say Kevin McCarthy ought to be out, Liz Cheney ought to be out, we ought to install Jim Jordan right now. And look, there's nothing that you necessarily need election for, right? The House caucus could change its leadership whenever it wanted. He'd be making that case, but he's not, because he doesn't want that fight, because he doesn't think he'll win that fight.
Or now, you sometimes, you just suggested that maybe Trump is just being Trumpy, and maybe he just likes the fact that Kevin McCarthy comes groveling to him. Multiple repeated phone calls, apparently, on Thursday and Friday.
Yeah, I think that's a big part of it, yeah.
And so, I guess what I'm seeing is all these figures in the Republican Party at the very top of the party still jumping over hoops and just bald-faced lying. Also, they can make sure they stay in the good graces of Donald Trump. I'm reminded of something that Mitch McConnell reportedly said to a friend not too long after January 6th. He said, I didn't get to be leader by voting with 5 people in the conference. And so it just seems to me that all of this just suggests that Donald Trump is still the kingmaker and is the sort of king in waiting. And that's kind of how things are playing out. Now, that might change after the midterms, but I don't really see any evidence that necessarily is going to change. I mean, I see our future as being extraordinarily Trumpy.
Well, we'll see. I think I would agree that it may be Trumpy, but this is going to sound strange. To some extent, perhaps Trumpy without Trump.
That could be even worse.
It could be. No, I agree. But that's my sense, right? Is that this is kind of now moved beyond. So, for example, right, Josh Mandel would be Trumpy without Trump.
Absolutely, yeah.
Which would be sort of the reason of Trump to say, okay, I'm back in Vance.
But Vance,
you see what I'm saying?
But Vance would also be Trumpy without Trump.
It's a sign of weakness.
Yeah,
it's a sign of weakness to say. Instead of like, I am so proud of my good friend, a longtime supporter Josh Mandel, that he's leading the polls. He's an absolute winner. He's been winning from day one. He's gonna win Ohio, but he didn't do that. He instead picked Vance, who was again I wouldn't say a long shot,
not at all
by any means. He was consistently polled in the top couple. But not the front runner.
Yeah, I think
it is sort of, to me, I see that as a need to reestablish Trump's status, if you follow me.
Yeah, I see what you're saying. I disagree with the analysis, but I see what you're saying. I think there's maybe more to the celebrity thing. I mean, he endorses Dr. Oz and these folks.
No, I think that's part of it too.
And so I think these folks win who wouldn't win otherwise, and he even strengthens his case even more going into 2024. And I wouldn't be surprised at all if Vance wins in Ohio and a number of Trump candidates win, and then next thing you know, like I said, you have the 2025. You have President Trump, Speaker Jordan, and holy crap, I guess I'm looking at Canadian citizenship or something at that point. I don't know. Anyway, but I guess we are kind of united in the sense that we see at least the next few years still being no diminishment of Trumpism. It's just maybe the extent to which you and I agree or disagree that Donald Trump will actually be that figure. Is that
correct?
Okay.
Yeah.
All right.
Yeah. And like I said, I see these moves as, again, the fact that he essentially, right? Because could you imagine the Trump of say, January 10th or something like that, confronted with the McCarthy statement?
Yeah, well, and that was obviously
how he would have responded. He would have said, McCarthy's got to go. McCarthy's disloyal to me. He's disloyal to the country. He's a rhino. He's a terrible, terrible person. Everybody knows this. People have been saying this for years, right? Well, but now he's sort of like, well, okay, he's apologized. It's forgiven.
Yeah, and again,
that's taking a step back, and that's showing that you don't have the power that you once did. That's the point I'm trying to make.
I get that analysis. I disagree with it. I certainly hope you're right. Well, I don't even know if I do hope you're right, because I think in a way,
if I'm right, the situation may well be worse.
Well, exactly. So yeah, it's either way. We seem to be united, I guess, in our pessimism, because neither of us really believes in that sort of Trumpist populism sort of thing, that kind of being the worst sort of faux conservatism, I think. Yeah. All right. Well, then on that pessimistic note, let's leave it there and move in.
Although, look, I am going to still go with what I started with, that these kind of dust ups between party leaders are not uncommon.
Sure. Yeah.
And it's just one of those. You can have plenty of times of Ronald Reagan saying in politic things about Gerald Ford and vice versa. right, and Bob Dole, and I mean, it's that just the natural tension, and you could even point out, between Bill Clinton and Al Gore and Barack Obama and Joe Biden, right?
Yeah, there's tension, but then there's saying to people in your own party that you think your president is so unfit for office that he should resign. That's
also
different.
consider he should resign with 2 weeks left in office.
Yeah, that's true.
So it's not a president. It's a little different situation. Saying your president should resign. Halfway through.
Sure.
We're voting to impeach your president halfway through or during the first year of the presidency, as opposed to saying, well, he should resign and let Mike Pence serve out 2 weeks as president.
Right. Yeah. I know. I think that's a fair point. Absolutely. All right. Well, let's move on and talk about a pretty important ruling. And this last week, federal district judge Catherine Kimball Mizelle halted enforcement of the Biden administration's mask mandate for all forms of public transportation. And in her ruling, Mizelle, who's a Donald Trump appointee, she rejected the CDC's argument that its statutory authority stemmed from a provision in the U.S. Code that allowed for sanitation measures in order to prevent the spread of communicable diseases. Now, in addition to this, Mizelle found that the CDC was in violation of the Administrative Procedures Act for not implementing the standard notice and comment period before the regulation was enacted. And the administration argued that it was allowed to do this based on what's called the good cause exception in the APA, which allows foregoing of this period if that notice and comment period would be, in the language of the statute, impracticable, unnecessary, or contrary to the public interest. And what Mizelle found here was that that for a very brief assertion of good cause by the CDC was really insufficient to meet their affirmative burden of clearly demonstrating why that notice and comment period could basically be dispensed with. Now, the Justice Department has appealed the ruling, though it seems to me that given that appeal is going to be heard by the conservative, moral or conservative leaning, 11th Circuit, I think it's unlikely that the administration is going to get the ruling it wants. And even if that did happen, it seems to me even more unlikely that the Supreme Court would let that stand because, just last August, the court rejected the CDC's claim that it could restrict evictions, and that claim relied on the exact same language that the mask mandate claim does. So, Jay, what do you think about this ruling and DOJ's appeal of it?
I think the judge got it right mostly. I could quibble on the notice and comment piece, right? And I think you could certainly say that when the initial rules were passed, you could make that argument. This was an emergency, urgent, public interest, had to do something right away, and we didn't have time for the notice of comment period, which can typically last like 90 days is I think the standard. But it's a little tougher to make that now when you've got to say, hey, I'm going to propose rule, when this has been going on for 2 years.
Right. So you're saying that they could have done an interim rule and avoided that period and made that argument, but this far out, there's no reason why they couldn't have had
exactly.
Yeah.
You could have said, hey, we're proposing, we're extending this and so forth. Let's have notice and comment. But they didn't. So that said, you hit the nail on the head when you said, look, this is the exact same statute that empowers the CDC, that the CDC relied on in the eviction case. And this one, I'll concede this is a closer case to me, I think, than the eviction case.
And can you explain why? Yeah, that's.
Well, I think it's, look, you're looking at and again, the language of the statute says. It talks about disinfecting, sanitizing, destroying animals, and then there's and take other such actions. It's what in the law you call a residual clause, or it's sort of the yada yada clause, right?
But you should point out. We should point out that the yada yada clause doesn't necessarily cover everything. For instance, if the secretary decided, well, everyone has to wear hazmat suits or something like that, that would be overly.
Yes, you sort of jumped ahead of me, Mike.
Okay, sorry about that.
No, but that's sort of the rule, right? Is that when you have the yada yada yada, that is to be read consistent with the list of things that came before it. It means like stuff like sanitizing, destroying animals, quarantining certain. The quarantine is actually in a separate section, but the judge's point, and this was the same one that the courts made in the eviction cases, was listen, this all talks about taking measures to essentially clean stuff up, and she relied heavily on the term on sanitation, and that is the question as well. Does sanitize mean clean stuff up, or does it mean keep in a sanitary condition? And she looked at there were two potential definitions for that, and then there was a definition, and even looking back to dictionaries at the time of when the statute was passed, how was sanitized used? And they also did this thing. It's the corpus linguistics study stuff, which I gotta tell you, Mike, I'm not necessarily crazy about that. Because I think there's a lot of potential for abuse. But what it does, it's sort of this database, and you look at usage of the word at the time to say, okay, what did it mean then? And the court came to the conclusion that, look, in 95% of the time, anytime the word sanitized was used, what it meant was not this keep or maintain a sanitary condition, which the government argued, well, that's what we're doing by telling people to wear masks, but rather it meant that other essentially going in and cleaning stuff up, removing an unsanitary condition. And so that's how the judge came out. And like I said, I think there's a closer call there in terms of what sanitize means and so forth.
Right, I see what you're saying.
But so what I'm saying is and just from a common sense standpoint, right? I think there's a lesser degree of separation between saying the CDC can require people to wear a mask on public transport versus we are going to overrule all the lease contracts in the entire country.
Right. Yeah.
You know what I mean?
Yeah.
It's a question of degree, and also a question of just the gravity of it, right? There's sort of the reasoning in the eviction moratorium was one step removed, that, well, if people were to be evicted, one, it's sort of, there's a pandemic on, there will be economic hardships. People might not be able to pay the rent. If they can't pay the rent, they might be evicted. If they're evicted, they might go to a homeless shelter or move in with relatives, in which case they might spread the disease further, all that kind of thing.
Yeah.
That's what I mean. I think that's one step further. So I think that's the easier case to strike down. This one's closer, but I still think the judge got it right.
Now, but there's this other wrinkle in this that related to something that called the Chevron defense, which is which is essentially a doctrine of judicial deference. It comes from a case in 1984, Chevron versus National Resources Defense Council. And the basic idea here is that the court should defer to how an agency interprets a statute, so long as that agency interpretation is not unreasonable, and this is in cases where Congress hasn't, spoken clearly and directly.
You've got to get to the first step of that. There's some ambiguity,
right? But it sounds to me like you're saying that, in a way, from what you were just saying, that this is a close thing. So this is not a sort of de facto unreasonable interpretation. And so if Judge Mizell is going to apply this sort of Chevron rule to this, then it would suggest that the agency's definition should be deferred to, since Congress hasn't specifically spoken to this in clear language, saying that, no, we don't want the CDC to do this. I mean, that's the correct interpretation, right, of how you would apply that to this, right?
Correct. Yeah. No, I don't know whether I said that the statute was ambiguous, right? I said there's I think that's a closer call. I don't know that you still say there's that ambiguity.
Well, isn't it ambiguous in that you made the argument that, it's a close call as to whether or not this is consistent with the things before, and you list those things, and that gets into the whole, the fact that she had to go she made such a point in her decision about, well, what exactly does sanitation mean here and there? I mean, you don't do that if it's not at least somewhat ambiguous, right? It's not like the CDC made an unreasonable case. And so it seems to me that what Judge Mizell is doing, like what a lot of conservative jurists have done in recent years, is said basically that, Chevron deference is kind of ridiculous. Justice Alito, I believe Justice Kavanaugh, some others have said that this is just not a good doctrine. And it totally makes sense to me, because if you're a conservative jurist, your policy preferences tend to be, well, we don't want administrative agencies to do things. And if you employ Chevron deference, you're basically saying, well, they can do stuff, right? Unless they're clearly. Right. And so to me, and to a lot of folks on the left, this is a way for conservative jurists to be able to essentially insert their own anti-regulatory, anti-government policy preferences into and essentially become judicial activist policy, not makers, but policy stoppers.
So I guess the first counter argument to that is what John Marshall said in Marbury versus Madison.
Oh, you're going way back. Okay.
I'm going way back. That it is, I'm going to screw this up. It's not exclusively the province of the judicial department to say what the law is. And Chevron essentially allows the executive branch to say what the law is. And that's constitutionally troubling. And originally in Chevron, I think the sense was, look, when we're talking about things that are technical, right, that are within the agency's expertise, and they're the ones who enforce the statute and deal with it every day, so they know the most about it. That gives us the idea was sort of the best of both worlds, right? That there is this, you have the access to government expertise, but at the same time, you still preserve this accountability.
And so that's where it sounds to me like you're starting to bring in something called the major rules doctrine, right?
Well, I'm getting there.
Okay. What? Go ahead.
But what, Chevron essentially, as it has evolved in practice, has meant is that it's not a matter. It's when you say defer, I think people should be clear. It's not just a matter of, hey, this is what the agency says it means. We're going to take a real hard look at that and give that some really solid consideration. It means defer. It means, it doesn't matter what we, the court, think the statute says. We're going to defer it to the executive branch.
As long as that answer is not unreasonable.
As long as there's an ambiguity.
Yeah, exactly. And so it's not like you're just saying, well, the agency said it, we can't, it's not reviewable. And I think that's an important distinction.
But also, again, John Marshall didn't say it's exclusively the province of the judicial branch to say what the law is unless there's an ambiguity.
Yeah, I see what you're saying, but I think the idea here, right,
the whole point would be, if there's an ambiguity, it's the exclusive province of the judicial branch.
Well, yeah, and it seems to me that the argument for Chevron deference is to say essentially that, well, we're not saying that the court can't say what the law is. Certainly the court can, because deference, as opposed to just blind acceptance, those are two different things. It's a question of sort of benefit of the doubt.
But in the Chevron context, not really.
I guess I don't follow, because to me, deference doesn't mean stepping aside. It means basically giving that agency interpretation a certain greater weight, a benefit of the doubt. But certainly you can rule against it.
But in practice, the way it works, because I would be okay with that, right? And there are a number of states. Mike, there's an outstanding brief that was filed in the Ohio Supreme Court just last week on this very issue. About how states apply Chevron deference, and there are a number of states who have either by judicial ruling or by statute established just that. That says, look, when the agency expresses, if there's an ambiguity, the agency can express its view on this, and the courts ought to give it, really some good weight, a great weight, even sometimes presumptive weight. That's different than saying we will just defer to, hey, agency, whatever you say. So there are different varieties, flavors, I guess, of Chevron, of deference as you go down the scale. And like I said, I think if courts want to say, well, we're going to give some special weight to the agency, I don't think that's inappropriate. from a constitutional standpoint. I do think it's inappropriate to say whatever you say, agency.
Right.
Because also,
I
if
agree.
you think in practice, and in this fantastic brief, Mike, it references actually studies that have been done about differing levels of deference in different states and how statutes and rules are written. Right? It's the agencies that write these rules, or it's the legislatures that write the statutes, agencies write the rules. There's also what's called hour difference, which is sort of Chevron, but just applying to the agency's internal rules. But the idea is that the more this happens, the more the administrative agencies write in order to get more ambiguity, right, to increase their power. And I think that's a problem. That's something we talk about all the time, right? Is that Congress deferring too much to the executive. And I think Chevron is one of the accessories to that crime, if you will.
Well, and sort of to try to deal with that, the court came up with this idea, at least conservatives on the court came up with this idea, the major rules doctrine, which is basically this idea that, well, if we're talking about minor things that don't have any kind of significant impact, then
right.
we'll defer.
You submit your form in triplicate, yes, signed with a blue ink signature on this day of March as opposed to that day. Yeah.
And so I guess you're okay with that as sort of a way to kind of mitigate what you see as the problematic nature of Chevron deference.
I think yes, it mitigates. I think we're overdue for a revamp, though, right? That of really looking at Chevron of can it stand constitutionally? Period.
And to be clear,
but in the meantime, I think, sir, the major question that's sort of one of those first fights in there, and that's sort of ground that has been taken back, and it kind of proves the point, because I think a lot of folks would say, look, when it's not these big policy issues that are really impacted, there seems to be less of an issue of deferring to the agency, right? If it is sort of just about how agency interprets, again, sort of the administrative pieces of it, or the technical pieces of it. But when it's the administrative agency reinterpreting the scope of what the statute entitles them to do, I think that's something different entirely. And I would say a rule that applies to all public transportation in the country and millions of people traveling every day, I think that would qualify as a major rule. So
is what you're kind of looking towards, or the idea that deference should be given in terms of the type of action, but not in terms of the actual authority or ability to act in the first place? I mean, is that the kind of distinction that you're getting at?
A little bit, although there's going to be some overlap there, right?
Sure, yeah.
Between type and authority. But I think it's the second thing is the much bigger problem, right? If you say, well, hey, we've got this statute that says we can propose rules, dealing with diseases and sanitizing areas, destroying animals, yada, yada, yada. Therefore, no evictions, or therefore everybody wears a mask on every public transportation carrier in the nation. Like, whoa, that's a bigger deal, right? That's sort of seems to be overstepping that mandate. And the other really test to look at is has this type of power ever been used or asserted before under that statute? And it really, again, you can say, well, look, 2020 was unique, and that's true to some extent. But in many ways, that uniqueness argues for exactly what some of the courts in the eviction cases said is, if Congress wants to do this, Congress can probably do it.
Yeah, and that's kind of where you and I know very much agree that in terms of even if an agency can do certain things, oftentimes it's better that Congress speak, because that puts that stamp of legitimacy on it in a way that you don't get with an agency action. There was
and I'll point out that the big example was in the eviction cases. What happened was Congress did pass an eviction moratorium, and that went for a certain period of time, and then it expired. And then what happened was the administration tried to administratively renew it, and that's what. Now there was a court in Texas that said that Congress didn't even have that power because it went beyond the Commerce Clause. But that's another case, and we're not there. But most of the other cases said, look, the fact that Congress did do this, and then stop doing it, and then the agency does it again. That's sort of indicative that the agency is exceeding its reach.
Right. It reminds me of there was back in the 50s when Harry Truman was president, and he tried to seize the steel mills essentially.
In Youngstown, Ohio.
Yeah, there you go. So
Youngstown Sheet and Tube.
Truman said the president has the power to keep the country from going to hell, and actually, no, the president doesn't have that power necessarily. And so I understand the policy arguments, certainly, and you can certainly make that point. But I would say Congress actually needs to authorize that, because we tend to forget, I think, oftentimes that the executive branch is supposed to, execute the laws and not sort of make the laws in the first place. And Congress has been complicit in this, right? The other piece of this is the non-delegation doctrine, right, which says that Congress can't basically transfer its legislative powers to an executive branch agency just to avoid having to make tough decisions, right? Which is what a lot of folks on certainly even on the right would argue Congress has done in some areas, like our never-ending wars in all kinds of places. And I think that's a reasonable case, and I think we have a Congress full of politically opportunistic cowards, basically, who don't want to make tough votes and say, well, let's just push this over to the agencies. If we don't like it, we can yell and scream at them, but this way we're not on the hook.
Yeah, and I would point out that the true sort of old-fashioned Whiggish conservatism, right? It's all about there's a reason that Congress is Article 1.
Yeah, absolutely. I totally agree with you there. And so the way to fix a dysfunctional Congress is not to just keep on trying to work around it. Essentially, I think and that's kind of where band-aiding the problem, trying to get around this sort of dysfunctional institution. That's not going to help make this institution any more functional.
Yeah, and I do want to take this opportunity though to take a swing at Dr. Fauci.
Of course you do.
And no, but first of all, one to congratulate ourselves and our listeners on this type of conversation that we're having, and to sort of contrast it with how Fauci and the CDC has set this out. He told CNN the principle of a court overruling a public health judgment by a qualified organization like the CDC is disturbing in the precedent that it might send. Those were his words. Send. Yeah. I think he meant might set maybe, but that's what he said. But he's the expert. And he went on to say the mask mandate is a CDC issue. It should not have been a court issue. We are concerned about courts getting involved in things that are unequivocally public health decisions.
Well, yeah, that's ridiculous. But
that's exactly sort of, and I've seen so much this on the left of who does this judge think she is? She's no public health expert. And no, but that's very much not the question. The question is never whether this is a wise or necessary policy. It's whether the CDC has the authority to enact it.
Yeah, no, and on that you and I.
And you
totally,
get that, and I get that. But Fauci doesn't.
And then there's this whole thing about how the judge was viewed as listed as unqualified by the ABA and that sort of thing, and
she's too young.
Yeah, yes. Exactly. I think she's like 35 or something like that, basically. But I think there's no question.
Which is pretty young.
Yeah, well, she's one of the youngest federal judges. But even so, even bringing up that issue, that seems to me to be essentially a non-starter. She's clearly one of those legal superstar folks. She clerked for Tom dumbest. She's probably smarter than the two of us combined with a whole bunch left over kind of stuff,
She's better looking too. I shouldn't say that.
So
right?
I'm gonna let that sit anyway. But yeah, I think that's kind of a non-issue that was raised. She was only listed as unqualified by the ABA because she had, I think, 8 years as opposed to what they generally want. I believe it's 12 years of prior experience.
But I think she was also like 8 years at Jones Day, which is like
it's way up
in dog years. That's like 40
exactly
people years. No, and I want to point something. This is just a little weird quirk about the legal world, and that is, and this is going to sound weird, right? But that whole experience piece probably matters a lot more on the district court and the trial court level than it does at the appellate court level. And that's going to sound counterintuitive. But again, it's just this weird thing of like, look, all these judges who have law clerks, all select law clerks who are just right out of law school, when they know absolutely nothing. Have them research and help write the opinions. And it's a weird, apprenticeship sort of thing. And the idea is it trains the law clerks and so forth. But it goes that appellate questions tend to be more these just straight ahead intellectual questions of law, right?
I see what you're saying. Sure.
Whereas in the hurly burly of the trial court thing, right? There's a whole lot more there's a lot more nuance, right? There's a lot more dealing with the parties and moving towards settlement and dealing with objections and evidentiary issues. Making sure the trial moves forward. There's a lot more of that just experience type stuff that would be needed at the trial court than at the appeals court. And I'm not saying right or wrong. I'm just saying it's a weird kind of function.
So basically, I would be a better appellate court judge than I would be a trial court judge.
Absolutely. Yeah. No, absolutely. Yeah. No, most people would, right? I mean, if you're a really good law student, intellectual, good reader, good writer type person, and again, there's certainly that comes with experience as well, but it'd be much easier to fit into that appellate world than to fit into
I see that.
The other world, which requires more just kind of management skills, if you will, right?
No, I get
that you only learn by experience.
Yeah, it's an interesting point. Huh. All right. Well, let's move on to our next story. There's something a little bit different. I've been calling it DeSantis versus Disney, but I guess it's really kind of like Florida GOP versus Disney. But anyway, so the Florida legislature this week approved a measure that would eliminate Disney's unique tax status, I'll call it, which basically allows them to operate as kind of an independent government entity on their lands. And there are a lot of folks who see this as the Republican legislature and Governor DeSantis basically punishing Disney, which is the state's largest private employer, around 80,000 people or so, for taking a public stand against what's been called Florida's Don't Say Gay law, and also the Disney CEO's decision.
Or as I like to call it, the Don't Teach Kindergartners through Third Graders about sex.
There you go. But anyway, and also Disney CEO said that they're not going to make political contributions in Florida anymore. And this is after decades of doing a whole lot of that, mostly to Republicans, including $50,000 to DeSantis's reelection. Now, this measure by the Florida legislature was passed by a very wide margin, and I should point out that there was no real effort made to even determine the financial impact of changing Disney's status on the state's finances. In fact, Democrats in Florida State Senate proposed an amendment that says, hey, maybe we should study the potential economic impact of the bill. This was defeated in a voice vote. And one of the key economic issues here is that there's nearly $1 billion in tax-free bonds that have been issued by Disney. And under Florida law, these obligations revert back to local governments. And so according to Florida Democrats, this would amount to an average additional tax burden of around $580 per person for the 1.7 million people in the counties that would be affected. And so I got to say, Jay, from my standpoint, this seems like Florida Republicans putting on their cultural warrior hats and saying, damn the economic consequences, we're going to show Disney who's boss. And I wanted to get your take on this.
So, in a lot of cases, I would very much be concerned about um, a state legislature taking aim at a particular corporation. Um, that said, I think the equation is a little bit different when it's a matter of we're just not going to allow that corporation what it has heretofore enjoyed as a unique status in the state, and really probably unique status anywhere in the country. And I think that's not. I don't see that as the heavy-handed government telling the corporation what they need to do. Um, when the government is, it's sort of look, the government giveth, government taketh away.
But, I mean, in other contexts, I remember you saying a number of occasions, hey, nice corporation you got there. It'd be a shame if something happens to it. It sure sounds a lot like me to that. I mean, and
it does. It does. And like I said, I think the distinction is, one, here's a corporation that's going about its own business. And, if it doesn't do what we want to do, we're going to go regulate the hell out of it. It's something different where, corporation, we have given you this unique status, both in terms of taxation and also in terms of self-government, that you get to essentially run your own sort of fiefdom over. It's a huge area, right? Your own sort of unelected government. And this allows you to build things that you wouldn't be able to build otherwise, and other rules you don't have to comply with. I think it's a different sort of situation where a corporation has existed and profited by a particular carve out, as opposed to just a Facebook or Twitter. We don't like the stuff people are posting. We want you to change it, or else we're coming after you. Or
But I mean, this is punitive, right? I mean, there's no question this is punitive.
Yeah.
And there's no question, it seems to me, and maybe you disagree, there's no question to me that in a way you can argue that this is fiscally irresponsible because no serious effort was made to kind of determine what sort of effect this would have on Florida taxpayers. I mean, $1 billion isn't nothing, right?
It might be, yeah. But of course, the fun part of this is those Florida taxpayers, those bondholders. It could be very much a boon to local Florida governments, right? You could make that argument, who have been struggling throughout the pandemic, and we're taking away a huge corporate tax break for this corporate behemoth.
But except
and
the
look,
way to make
these
that
bondholders can take it up with the corporation and say, listen, we came in hoping we could get these tax-free bonds, and now you've screwed it up. Maybe you ought to reconsider.
Yeah, I mean, I almost can understand Florida doing this, but it just seems to me to be, a primary obligation of the legislature is to, ensure the economic well-being of the state and its residents. And the fact that this was done without any sort of, due diligence, I guess, just strikes me as being the height of irresponsibility.
I don't know. You're usually less concerned about due diligence when it comes to tax increases.
Well, that's just not the case.
This would be essentially a tax increase on people who hold these bonds.
Yeah, no, and that's I mean,
it's not a broad across the board tax increase. Now you could say, listen, this could affect a major employer, and maybe they don't hire as many people or what have you. I suppose that's a possibility.
Well, I mean, no, the very fact we know for a fact that there's that under existing Florida law that close to $1 billion in obligations reverts back to the states, those local governments in those two counties. And so that's not like a deeply, we don't know what's going to happen here. We know for a fact that at the least is going to happen. And I would say that.
Well, there you go. You did your fiscal analysis.
I mean, but there's a
Good
lot.
job.
There's a lot more than that, obviously, and clearly, I guess I would push back on the argument that I am just kind of cavalier about this when it comes to tax increases, because I always look at what the CBO and other projections are, and maybe you disagree with those conclusions, but I think it's just not correct to say that I don't consider that when it comes to tax increases.
All right, fair enough.
And and this is part of a larger trend, right? I mean, last year in Georgia, the legislature threatened to raise taxes on Delta because of the changes that Georgia made in voting laws.
See that I think is, to me, that's a much bigger problem, right? Of saying we're going to raise taxes on one company, if it is just raising taxes on it. Now, again, if it's a matter of again, we're not going to give you the special privileges that you heretofore enjoyed, I think that's a different question.
See, and I wonder, because the argument I would say is that if you are in a situation where a corporation or an entity has enjoyed a status for an extended period of time, I mean, this is from 1967, I believe it was, so well over half a century now. And so this is in effect, the level of the playing field, and has been for a long time, and just with no notice, no negotiation, no anything, just saying, oh, we're going to pull this. I don't really see, I understand that it is a difference technically, but the idea that it is any kind of a real world difference, I don't think so. So I understand. I think it's a difference, distinction without a difference.
That this is the only one, right? This isn't just a, look, there is, for example, say there was here's the airline tax, right? Here's what, here are certain tax breaks that airlines are entitled to, right? And it would be industry wide across the board. This is one particular company.
Yeah, I get it. I understand. I understand what you're saying.
I think that's different.
But I think it is. I think it's a technical distinction, but I don't think it's a real difference in the end. And so I guess, though, you would also say then, for instance, that in Texas they were talking about not allowing Citigroup for underwriting their bonds unless Citigroup changed its policy of paying for employees to go out of state to get abortions. That would be the kind of thing you would object to as well, as being like singling out a corporation.
Citigroup not to, okay, let me follow this.
Citigroup's policy at present is to pay for employees to go out of state to get abortions if they choose to, obviously, because of Texas, they can't in Texas. And Texas legislators said, well, if you keep on doing this, we're not going to let you, Citigroup, underwrite any more state bonds. Is that?
Yes, I would oppose that.
Okay. So I see what you're saying, and I think your heart's in the right place on this, but I think you're making a sort of a legalistic technical distinction that doesn't matter. But although I will go back to, with the Citigroup stuff, there's probably some degree of discretion, right, in terms of who the state chooses to underwrite various bonds, right? It's not like an entitlement. It's not a we are going to, again, tax you more, or we are going to pull business you already have, change contracts or something like that. We just might be not as friendly to you going forward. Yeah, this would be saying
the latter. I think that's just plain old politics, right?
Well, it's one thing to say
that happens. Oh my, you would have no idea in treasurers' offices across the country.
Well, it's one thing to say, well, we're going to be not so friendly going forward, kind of privately. It's another thing to actually pass legislation saying you are barred for competing for these.
Agreed.
I mean, that's a whole different.
No, that's what I mean. I think so. I think if the treasurer were to say, listen, I've got some real problems with some of your policies, and if you want to get our business, because in that case, it's a business to business essentially transaction, right? It's not the government coming in and passing a law saying you must do this or must do that or can't do this. So yes, if it's the latter, I'm okay with it. Putting it into statute, I think is bad.
And I guess this is what concerns me, and this is part of what depresses me, I guess, about the Republican Party. For the last half decade or more, actually, is that it seems to me the wing of the party that said, we're about fiscal responsibility. And I may have disagreed with some of their ideas about that and, enterprise and libertarian kind of ideas, to now I see the party in many instances pivoting toward being, well, we're going to put these social issues first and foremost. Now, in part, obviously, that's a rhetorical sort of thing and done just to kind of bring the kind of traditional values warriors, if you will, kind of into the tent and get them energized. But when that starts to come at the expense, in a very real sense, of what's supposed to be a bedrock, conservative fiscal responsibility. That to me, and I think that to any kind of traditional conservative should be troubling.
Yeah, but let me hit that. There's something else that's going on recently that hasn't been going on for that long, and that is corporations wading in a big way into these sort of social questions, and often wading in a misinformed, unthinking way.
And who
Right.
gets to decide that?
For
The
example,
government?
when all this legislation was proceeding through the Florida legislature, Disney was silent. Right? They've got, I'm sure, an army of lobbyists, especially in Florida. No one said boo. Then all of a sudden, when some woke Disney employees, kind of egged on by the left, said this is, and the media dubbed this as the "Don't Say Gay" bill and all that sort of thing, threw a fit. Then Disney management caved, and all of a sudden, this is the worst bill ever. This is terrible. How could this happen? We're not going to allow this to go forward. That's essentially playing dirty pool. And I think
I'm dirty pool. Explain what you mean. Why is that? That's just simply, isn't that just a private corporation responding to pressures from, legitimate concerns from employees in the market? Isn't that how markets are supposed to work? That's dirty pool.
But it's disingenuous, isn't it? It's kind of like again, canceling the All-Star game and what Coke and Delta and all those companies did.
How is it
do you think they
disingenuous?
really believed that was Jim Crow 2.0? Of course not. Do you think the Disney management really believes that this bill was a big issue? No, because otherwise they would have been watching it. They would have had their lobbyists. They could have spoken up at any time and said, "Listen, here we have some concerns. Let's address them."
Well, how do we know what? No, I disagree.
They sort of laid in wait.
I disagree. I think they did not necessarily know how big of a deal it was to people that work for them and to people that.
But Mike, they have lots and lots of very, 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 very highly paid people.
Oh yeah, and very.
Is it to watch these things?
You are the guy who not too long ago on a regular basis questions the ability of experts to predict these things. Come on, Jay. Sure, they may have ideas about what's going to hit big and what's not going to, but they don't necessarily know. And the idea that they're being disingenuous by responding to what I feel are legitimate concerns from employees and the public—that's not disingenuous. I think that's just smart, responsible business.
Mike, they know. Well, let's put it this way. Is it smart, responsible business to say, yes, employees, whatever you think the bill says, that it says?
But I don't think they're saying that at all. I guess that's
they're
where we
jumping
may
on
differ.
the bandwagon, right? And again, this is...
I'm on the bandwagon too.
And there is no question. Again, if you understood how the lobbying world, there is no question that everyone knew about this.
I'm not saying they didn't. No, don't understand. I don't misunderstand. I certainly, of course, they knew about this, but they didn't necessarily know the sort of outrage that it would inspire in certain elements of the public. And so, yeah,
But here's the thing, Mike. You and I did.
You and I did what?
We could see the outrage coming.
Well, you always see the outrage coming. So no, I don't know.
What I'm saying is, we're people not on the ground with just a little bit of information here, can see how this thing is would blow up.
I see what you're saying, but
so Mike, the way this works, right? You have these these legislative hearings, and you go to the hearings, and you sit there for hours and hours, and all sorts of people come in and raise their concerns. And your job as a lobbyist is to sit there for hours and hours listening to all this and then report back to someone. And obviously, some of these concerns were raised by someone, during this process, and that no one ever saw it or now says they didn't. I think that's just nonsense. That's why I'm saying it's disingenuous. And if you are
I get you. Okay, well,
if you're
sure,
a corporate
yeah.
player, right? If you're playing the game, right, and you're playing it responsibly, and when I say playing the game, I don't mean to imply something improper, right? In fact, I'm trying to imply something proper, right? That there are certain rules. Like, look, in the legislature, say if you if you're a lobbyist and you represent a group, and you go to the bill sponsor, says, "Hey, are you with us?" You say, "Yes, we're with you. We're not going to oppose." That's a big deal. And again, this isn't written in the Constitution or in statute or anywhere. This is just the you don't throw at the batter's head
Sure.
type thing. This is just human trust. This is how it works. And people who would abuse that at some point, they're not going to get the same response, the same traction as others. And companies that do things like, you have legislators say, "Hey, this okay with you? Any objections? Nobody object? Okay, we're passed." And then all of a sudden you come in and, oh my God, this is an assault on basic human rights. I can very well see why the legislature and the governor would say, "All right, we're not,
So basically, it sounds to me
this is throwing at the batter's head."
so responding to concerns of your employees and your patrons is somehow out of bounds. I guess that's I understand what you're saying, but the idea that, well, obviously Disney didn't want to make a big deal out of this if they didn't have to, because they have a lot of longstanding cozy relationships with Republicans in Florida. I mean, that's why they've given them most of the campaign money. It seems to me Disney just said, well, we hope this isn't going to be a thing because it can cause a real problem for us, because we like where the Republicans are in terms of tax and economic policy, but we're a little uncomfortable with the social stuff. We're going to see what happens here and keep our fingers crossed. And they made that bet and they lost that bet.
Yeah, but I guess let's put it this way: if you are a Republican in Florida or elsewhere, and you have companies that keep coming to you and say, "Listen, we really need some help getting some breaks on taxes and regulatory issues. We're getting killed out there, and look, if you stick your neck out for us, this is really going to be helpful for jobs and growth and the economy of your state." And you're the Republicans, and this is however many times Lucy says, "I'm going to hold the football. I'm not going to pull it away." After so many times, when then you do this, you stick your neck out for them, spend political capital, and then they come back with, people are violating civil rights. You're the worst in the world. At some point, you just say, "No, we're not doing this anymore." I completely understand that.
I think you're these poor victims in the legislature. It's so tragic how these folks are just being victimized. My eyes are rolling.
I'm not saying a victim. I don't think is the right word. But it's a matter of can't keep.
I understand what you're saying. You're saying that if Disney is going to the Florida legislature and saying, "Hey, we want all this stuff," and in exchange, the legislature say, "Well, okay, just don't badmouth us, and we'll keep on giving you stuff, but don't expect us to give you stuff if you badmouth us." And that certainly is reasonable. But these are all self-interested players who are kind of weighing the pros and the cons, and I don't think there's a hell of a lot of honesty on either side of this, actually. And so it's just a matter when those sort of fortunes, when that weight, then when that balance changes. And my question is, well, it seems to me, or my observation is, it seems to me that right now the Republican Florida legislature and the governor, who has his eyes on the White House, obviously, is making the calculation that it's worthwhile to stick Florida, at least in those two counties, Florida residents with a pretty significant tax increase if it means that it can kind of rev up the base on these social issues.
So one more thing that I think is very much worth noting that very few people have noted: this bill wouldn't take effect until next year. Meaning, I think what's happened is DeSantis has sort of responded and laid down the gauntlet. And if I am these Disney lobbyists,
So it's Vito coming to the store saying, "Hey, these windows, they look like they could break pretty easily here." I see what you're saying. It's the shakedown part. Gotcha.
It is some to that. Say, listen, you are now putting your tax exempt status. You have put your tax exempt status at risk. It could change. Maybe we can work something out. But I mean, I think there's also, I think just there's an anger that I don't think a lot of folks on the left understand or see. And you see this in the vast numbers of how overwhelming the bill passed, of this government getting into. And I want to say something just about on the merits of the bill. We talked about this a couple of weeks back. But aside from the metric system, trains, and the post office, the other thing that progressives love more than anything else is teaching other people's kids about sex. And it's been sort of a perennial thing, and this is sort of the most recent iteration of it. But a lot of people, when you tell them, hey, you think it's appropriate to talk about sex, gender issues in kindergarten through third grade? Most people would say, no, I don't think that's appropriate, and yet the bill didn't arise in a vacuum.
Yeah, but Jay, I mean, again, this gets to this issue of subsidiarity. It's like, well, who should be making this decision? Do you want the state government to be making it, or do you want the local school boards to be making it, or would you rather have this dictate come down from on high as to what your local school can and cannot teach? And so to me, this is just like taking traditional conservative values about subsidiarity and local control and flipping them on their head to push a cultural agenda.
I think the issue that so many people have seen is, one, they don't know about what's going on until after it happens. Right. And that's part of the issue, the lack of transparency with local school boards. And that's not to say all of them, but certainly some of them. And I can tell you, as someone who has litigated these kind of like public records requests, you'd be surprised the unwillingness to share what is public information that taxpayers are paying for. So I understand that, and I think you're right. I would prefer that things be handled at a local level. I think that's a much better way to go. But the reason you see these things of the prohibitions of, look, you can't do this, is because there's the sense of it is being done, and people aren't finding out about it until late. They're not getting the opportunity to say yay or nay at the local level. It's just happening.
But they can change
and then
that.
The states react.
I mean, it's exactly the sort of action you criticize when the left does it. It's just that it happens to be an advancement of a goal that you believe in, and so it's okay in this sense.
How so?
Because it's not. I mean, the idea is that, right? Well, at the local level, it's kind of messy
I oppose states having non-mask mandates. Right, I said that should be a question for local districts.
Well, I'm not saying as a blanket sort of thing, but in this instance, it seems to me to be, again, inconsistent. I don't buy I think your argument that, well, people don't know what's going on at the school board level. Well, sure, if they want to get involved enough and go to those meetings and have a role in policy, well, they can certainly do that. But that's the
thing. It's not going to be. They're not going to say, hey, next on our agenda, we're going to talk about whether we should provide, gender education and sex education for kindergarten through third graders.
So people are going to have to actually pay attention. And you make the exact same argument, it seems to me, when it comes to voting, saying, hey,
of not paying attention. It's I'm not sure there's no. If it's never comes up for a vote, it's not a matter of you can't pay attention. Because that's what I'm saying. It's not on the agenda. It just happens, and then afterwards, parents show up and say, "Hey, we don't like this."
And then you
at
can
which
take
point-
action by ousting school board members and electing people who are going to do the things you want. This is how representative democracy works. And I'm sorry if it's messy, but it seems to me that's exactly the argument that you've made in other instances about voting, saying, why should we make it so easy? It's important if people care, they should get involved. And so, yeah, that's why I get what you're saying. I just think it's just kind of on a basic level, kind of wrongheaded and inconsistent with conservative.
I'm trying to explain why I think in this case the state has stepped in. Now, part of it obviously is political self-interest and
Sure.
jumping ahead of a train you want. That's given. But I think there's a difference in that people have the sense of they are not able to have that conversation or have that debate in their local school boards.
And that's
because
wrong.
one, it just happens without their knowledge, and that's really a lot of, I think, of one of the reasons why so much of this happened right after the pandemic, right? Is all of a sudden people were seeing classes, we're seeing what went on, and there was all of a sudden a veil lifted for a lot of people, and there was also a sense of frustration by parents of schools not coming back into session in person, and yet getting lots of money and spending the money on other things, like plans to teach their kids about, their kindergartners about what their gender ought to be.
Well, yeah, and that's why obviously you're exaggerating for effect. But we won't get in. We talked about that a few weeks. Yeah, we talked about that a while back when we talked about the law itself. I would argue that you are mischaracterizing it for comic effect, but that's okay. I mean, in this context,
I guess to some extent, Mike, as long as if the comic effect is achieved.
Yeah, that's the important thing, right? Yeah. All right. If you are a Politics Guys supporter, the rest of our episode is coming right up. We're going to be talking about the latest in Russia and Ukraine, and tax day and tax policy, and 420, which was this last week, and pot policy, and also our uniquely stupid last decade and social media, all that. If you're not a Politics Guys supporter, just a quick reminder, full episodes, ad-free, run around 2 hours or so. They're available to our Patreon supporters, as well as to anyone who's not in a position to financially support the podcast. To become a Patreon supporter, just go to patreon.com/politicsguys. You can also support us on Venmo or at Politics Guys, as well as through PayPal. And you can find all support links. They're in the show notes and also at politicsguys.com/support. And if you are in that position where you're just not financially able to support us right now, but you want that access, send me an email, mike@politicsguys.com, and I will get you all set up. And whether or not you're a supporter, it really helps us out if you can subscribe, rate the show, and leave a review on whatever podcast app you use, as well as sharing episodes on social media. Thanks so much.